court must leave it to Gecom to exercise the powers that it has under the Constitution and under Section 18 to manage this election to a result that Gecom considers to comply with the law.
That was Senior Counsel Douglas Mendes, who is representing the People's Progressive Party Civic Presidential candidate Irfan Ali and General Secretary Bart Jagdeo during his submissions today before Chief Justice Acting Roxanne George. The Trinidadian Senior Counsel pointed out that as a first instance court, the High Court is required to allow Gecom to complete the electoral process before hearing matters on any disputes from the elections. This process, Mendes noted, has been upheld in several courts, including the High Court itself, as well as the Court of Appeal and the Caribbean Court of Justice in previous matters brought on the current electoral impasse.
You have no jurisdiction in these proceedings to determine whether Section 22 is unconstitutional. You have no jurisdiction to determine whether Order 60 is valid. You have no jurisdiction to determine whether the recount is valid. You have no jurisdiction to determine whether the declarations made by Mr. Mingo are valid or not. You have no jurisdiction to determine any of those things simply because the law says that all of these matters are to be determined on an election petition, so that this case is a non-starter.
He cited authorities in which the law is very clear, whereby if unlawful advice is given, then the party receiving the advice is not obliged to act upon it. Similarly, he argued that the Elections Commission cannot act upon the fraudulent figures being submitted by the Chief Elections Officer, Keith Lowingfield.
If it turns out that there's a rogue CEO who is ignoring the declarations that have been made and giving his advice on the basis of something that he invents himself, then Gecom is entitled to say, well, I can't act on that because that will be unlawful. And that becomes part of Gecom's power to manage the elections, which the Court of Appeal has said that the court will not inquire into until under an election petition.
According to Senior Counsel Mendes, as much as the Chief Elections Officer does not want to act on the recount results, he must obey the law, that is, Section 18 of the Elections Laws Amendment Act, which says he must act under the direction and control of the Elections Commission.
He's a public officer and he must obey the law, and he must, at this point in time, reserve his opinions as to what is right and what is wrong, and leave it to the court under Section 163 to determine whether his viewpoint is right. That is the only way to resolve this impasse at this point in time, milady. And that is as much as this court can do to direct the CEO to Section 18. You cannot determine whether Section 18 is constitutional because, again, that would be doing the very same thing that the Court of Appeal of Guyana says that you must not do. You cannot determine the constitutionality of Section 22. You cannot determine the lawfulness of Order 60. None of these things can be done at this stage. The CCJ has made that very clear. Get the election over. Get a government that reflects the will of the people into office, and then resolve all of these legal disputes later on.
Following today's 5-hour hearing, the Chief Justice announced she will deliver her ruling on Monday, July 20 at 16 hours. Reporting for the Evening News, Vanu Manikchand.